Good morning, friends. Welcome to Legal Matters by Sai Baba Sunkara. We are going to discuss the topic private nuisance. In the last video, I told you about the public nuisance, and now we are going to discuss the private nuisance. Please remember. So here, the defendant is likely to interfere with the possession or with the right of the person unreasonably, unnecessarily. These two words, legal words, don't forget. Then only the so-called nuisance of private nuisance will be attracted. If there is unreasonable and unnecessary interference into your right, it is called private nuisance. As already told you, it is not against the community, it is only against a particular individual or a two or more persons, that's all. So to cite example, already I told you, your neighbor raised the volume of his TV so that you can't hear anything in your house. So definitely it is a private nuisance. Second, your neighbor planted some trees, right? Branches of them had grown up and actually they are breaking the tiles of your house roof, or they are breaking the compound wall. So it happens to me personally, it happened to me. Yes, definitely it's a nuisance. Now we will discuss the case laws. Shanmugavel Chettiar versus Sri Ram Kumar Jinning Farm 1987. Just like Dr. Ramraj case, this is also similar case. Here what happened is Sri Ram Kumar Jinning Farm. Actually, it was started by the plaintiff. So that they are running the ginning mill, right? In the meanwhile, please remember the defendant, that is here the appellant, Shanmugavel Chettiar. He has started a brick factory. There it's a brick grinding machine. Here it's a brick factory besides the ginning mill. Right? So what happened is ginning mill. So lot of cotton will be there. Brick factory. Normally the sparks of the fire will be coming out. So definitely there is a very danger that the cotton may engulf in fire. And secondly, due to the dust from the so-called ginning mill, so normally the humidity is gone and the quality of the cotton is also gone. The purchasers, that is the buyers, they will not come forward to purchase the cotton if it is with so much of dust. So the dust of the bricks is spoiling the quality of cotton. Therefore, they are getting annoyed and nuisance is caused. Aurangabad High Court, admitted the argument and granted injunction. Even what is injunction? Injunction is nothing but a restraining order to do or not to do something. So when we discuss the CPC under Order 39, Rules 1 and 2, we will be knowing what is an injunction. For the present, please know that injunction means a restraining order. An order saying that don't do it. An order saying that don't interfere with it, like that. Injunction order was given. So please remember, in law of torts, normally we get compensation, but at times we may get the injunction orders also. So in the last video I told you that the nuisance can be filed as a civil case also. Civil case, section 93 of the CPC. What for? Normally for getting injunction. In criminal cases, you will get only conviction, that's all, or punishment. In law of torts, you get some compensation. But in civil cases, definitely you can go for injunction, right? So second case, Radhesham versus Guru Prasad, 1978, right? So actually, Guru Prasad, he filed a civil suit against Radhesham for installing a flour mill. Flour mill, definitely it gets rattling sound. Flour mill gani, karam mill gani, dada sound vasta untai. In 1978, nowadays sound taggindఅనుకోండి. But anyway, the rattling sound of the rice mill, or that is flour mill, caused nuisance to the upper floor residents. So you may be knowing, normally if the nuisance is there, if the mic nuisance also, the ground portion persons, they may not hear that much, but people in the upstairs, definitely, since it is open to the sky, they will be hearing the sound and they will get annoyed. So the rattling sound of the flour mill caused annoyance to the residents in the upper portion of Radhesham. Yes, the court admitted the argument on the grounds of private nuisance and it has given injunction order. See how beautifully the cases are analyzing the matters. Third case, St. Helens Smelting Company versus Tipping, 1865. Right? So here, zinc smelting plant. So zinc, for the process of zinking, normally smelting operations will be done. They create some bad smell also, and the flora and fauna or trees around the area, definitely they get affected, and so after some time they withered away. Of course, due to the industrial policy, to the development of industry, these people encouraged in the beginning. Actually, it's located in between Canada and USA, in the Washington state, I believe. So just by the side of a river. But in the beginning, Washington, they encouraged them. But when the area is being disturbed, when the nearby people are getting nuisance, they have ordered for the closure. They have ordered for some compensation. They paid the compensation, and once again, they have started enhanced their activity by running extra tons capacity. But this time they have turned the tower to the Canada side. Of course, there also they started damaging. People got, definitely it's a public nuisance. So actually here the St. Helens Smelting Co. they took the plea or the argument that it is for the industrial policy. That too, the persons should not develop any plantation in that particular area. But this defense is not agreed. The claimant, the defense that the claimant can cause damage as a part of smelling pump operations, definitely it is treated as a nuisance, and he has ordered to close the same. Then Alapati Venkatrao versus Nizampatnam Sachinana, 1980. Actually, so Nizampatnam Sachinana, he wanted to start rice mill in some town near the residential locality. Please remember, if you want to construct or start a mill, definitely you have to take no objection certificate from the neighbors. That is, the neighbors should say that yes, we are not worried about the nuisance to be caused by this rice mill. Then only permission will be granted. So when he approached, then Alapati Venkatrao filed a petition against them. The matter went to such a stage that an inquiry committee, an expert committee has been instituted in that function. So these people have clearly stated that it will become a nuisance, because the vibrations of the flour mill, of the rice mill, they may emanate from the mill, disturb the mental peace of the inhabitants. Ratripura dada sound, definitely people in the area, they will not have a good sleep, and they will disturb the sleep of the neighbors during the night. So the smoke and dust which emanates from the rice mill will spoil the health of the inmates. So on appeal, court said that yes, it is a public nuisance. You cannot construct a mill. Go to the outskirts and start the ginning mill. So very good case laws. Please remember. So the defenses are very, very simple. Vigilantibus, stantibus, vigilantibus, non-dormantibus, jura subvenient. So please remember, it says that law will comes to the rescue of the persons who are alert, who are vigilant, who are awake, but not to the sleepy or slumbering persons. అందుకని లిమిటేషన్ యాక్ట్లో మీకు చెప్తాను. ఎందుకంటే ఎప్పుడైతే మనకి ఏదన్నా అర్జెంట్, మనకి ఏదైనా జరిగినప్పుడు ఇమీడియట్లీ ఐదర్ యూ హావ్ టు గివ్ ఎ రిపోర్ట్ ఆర్ యూ హావ్ టు ఫైల్ ఎ కంప్లైంట్. కోర్టులన్నా వేయాలి. ఏమి లేకుండా 10 సంవత్సరాల తర్వాత నేను ఇప్పుడు వేస్తానంటే ఎవరు ఒప్పుకుంటారు? దట్స్ వై లా కమ్స్ టు ది రెస్క్యూ ఆర్ హెల్ప్ ఆఫ్ ది పర్సన్స్ హూ ఆర్ అవేక్, హూ ఆర్ నాట్ స్లీపర్స్. దెన్ లా ఆఫ్ ప్రిస్క్రిప్షన్, కొన్ని సందర్భాలు న్యూసెన్స్ అంటాం లేదు, ఎందుకంటే అడ్వర్స్ పొజిషన్ అని, అలాగే లా ఆఫ్ ప్రిస్క్రిప్షన్ అని. అంటే ఒక ఏరియాలో మీరు కొన్ని సంవత్సరాల నుంచి ఉంటే ఈజ్మెంట్ రైట్స్ మీకు ఆటోమేటిక్గా వస్తాయి, అప్పుడు న్యూసెన్స్ అంటే ఒప్పుకోవడానికి లేదు. అలాగే ద గవర్నమెంట్ ఈజ్ ఆథరైజ్ స్టాట్యూటరీ అథారిటీ. గవర్నమెంట్ ఇది ఆల్రెడీ ప్యాడింగ్టన్ కార్పొరేషన్ వర్సెస్ క్యాంబెల్, ఆ కేసులో కూడా చెప్పడం జరిగింది. అది కాకుండా ఇంకో కేసు కూడా ఉంది, ఇది ట్రాఫిక్ తగ్గించేశారని చెప్పి ఒక ఆయన చెప్తారు. దట్ ఈజ్ బెంజమిన్ వర్సెస్ టామ్, 1874. సో ట్రాఫిక్ వాళ్ళు వాళ్ళ షాప్ దగ్గర ఉన్నప్పుడు చాలా కార్లు అక్కడికి వచ్చి ఆగి లారీ లాగి కాఫీ తాగుతూ వెళ్తూ ఉండేవాళ్ళు. బట్ అక్కడ యాక్సిడెంట్స్ ఎక్కువని ద పీపుల్ డైవర్టెడ్ ద ట్రాఫిక్ టు సమ్ అదర్ ఏరియా. అక్కడ నుంచి ఆపకుండా పంపించేశారు. వీళ్ళు ఆపలేదు కాబట్టి నా బిజినెస్ డ్యామేజ్ అయిందని టార్ట్లా వేస్తాను. ఆయన స్టాట్యూటరీ అథారిటీ ఎస్ యూ కెనాట్ హెల్ప్ అని చెప్పి అది యాక్చువల్గా డామ్నమ్ సినే ఇంజూరియాలో వస్తుంది, మనకు వస్తుంది. అలాగే వాలంటీ నాన్ ఫిట్ ఇంజూరియా, ఇఫ్ యూ వాలంటర్లీ willfully agree for the nuisance, we can't help. So factories emitting gases and residents volunteer to stay, అక్కడే ఉంటారు కొంతమంది. సో దానికి న్యూసెన్స్ అంటే ఎట్లా? అలాగే హైవే పక్కన, రైల్వే స్టేషన్ పక్కన మీరు ఉంటారు, ఎవరేం చేస్తారు దానికి? వీ కాంట్ హెల్ప్. Then nuisance by several. This is also can be taken as a public nuisance, but normally court will not agree. అపార్ట్మెంట్స్ లో ఉంటాయి, పై పోర్షన్ కూడా కింద పోర్షన్ లో న్యూసెన్స్ చేస్తుంటాడు, అంటే చెత్త అంతా ఇక్కడ పడేస్తాడు. యూ కెన్ ఫైల్ ఎ కేస్, బట్ కోర్ట్ విల్ సే అరే బాబా యూ యువర్ సెల్ఫ్ ఇట్ విల్ డిసైడ్ డెఫినెట్లీ. సో ఇట్ ఈస్ అన్ ఎక్సెప్షన్. సో please read all these exceptions and definitely you will get a question either private nuisance or public nuisance. So with this thing I am stopping. Thank you very much.